Let's see if we are live. Have to wait a second for it to connect. Hello, everyone. I see it is live. Excellent. Happy New Year's Eve to those of you still on that side of the dateline, and Happy New Year to those that are not. Today we're going to talk about a case that's near and dear to my heart. I'm not involved in the case, but these kinds of cases are my entire practice. These are cases where people get sued by a civil copyright plaintiff, not a criminal case, but a civil copyright plaintiff who sees activity on BitTorrent file sharing networks like the Pirate Bay, which I realize is not a network, that I'm just simplifying here, and then files a lawsuit based on seeing that activity alone, and then hopes to connect the dots later in a court case in a convincing way to convince a judge that they have made their case, that they can tie the infringement to a particular person sitting behind a particular device, a computer device, and can prove in total that there's copyright infringement here. This company, Strike 3 Holdings, is sort of the second, maybe they're fast becoming the first largest filer of new copyright litigation in the history of copyright. Over the past 10 years, there have been over 13,000 cases between Malibu Media and Strike 3 Holdings. I've represented in one way or another or consulted in over 2,000 or 3,000 of them, and I've directly represented in over 1,000 of them. So these are really near and dear to my heart. I find myself with the legal philosophy that the plaintiff really shouldn't be able to file and maintain these lawsuits based on the threadbare evidence, the thin thread of evidence showing that some activity somewhere happened on the defendant's happened on the defendant's internet connection. So if they see it on the internet connection, is that really enough to connect the infringement to a particular person? Well, no, by itself, that's not. But should they be able to get into court and get to the discovery of relevant evidence, and in this case, ask for a copy of the defendant's hard drive? Let's take a look at the case, and then we can talk more about what I think about it. But I thought this would be compelling for you because we all have a sense of justice and fairness, and along the way, was it really fair to search the entire hard drive of a defendant who is accused of copyright infringement, but the plaintiff hasn't proven it yet? And this is the fishing expedition that would be used to find the evidence. So this is in the Central District of California. This is before Magistrate Judge Sherry Pym, and this is Strike 3 Holdings versus John Doe. And this was just decided a few days ago on December 27th. Introduction. On October 21st, 2021, Plaintiff Strike 3 Holdings LLC filed a motion to compel Defendant John Doe's responses to its requests for production. The way this works, when you're in the middle of litigation, when you've gotten past the pleading stage with the complaint and the answer and some scheduling and all that, the parties enter discovery. All information that is relevant to the plaintiff's claims or the defendant's defenses, all relevant information is discoverable. If I'm accused of a financial crime and I have bank statements, well, they can ask for bank statements. If I'm accused of a financial violation in a civil matter and my bank statements would show whether or not I committed the violation, then I have to turn those over. It's not the same thing as the Fifth Amendment right to not testify against yourself. This is not a criminal matter, and these are not testimonial. So the discovery of relevant evidence is something that the parties have to comply with, or else face a motion to compel. And if you still don't comply, face sanctions. We saw that with the recent Malibu Media hearings, where Malibu didn't comply with both discovery and the judgment. So this motion was supported by a joint stipulation, a declaration by the plaintiff's attorney and their computer forensic experts. The defendant's position was supported by their attorney's declaration, Curtis Edmondson. And then here's where the judge starts. Plaintiff is the owner of various motion pictures that are tailored for adults. These motion pictures are distributed through various websites and DVDs. Plaintiffs allege that Defendant used BitTorrent to download plaintiff's motion pictures and, of course, distribute them to others as BitTorrent does, committing copyright infringement. As relevant here, plaintiff served defendant with a first request for production of documents asking for a forensically sound copy, a mirror image of his hard drives, and a complete copy of all files contained on cloud-based storage systems. Defendant objected, indicating the requested materials contained private family and financial data, as well as information protected by the attorney-client and spousal communication privileges. And this is where we're going to break in, because when we think about turning over information, you can ask the other party to turn over the information. But do they really need to turn over their entire hard drive? Let's analogize this to more in real life. Let's say that you have a company. The company has records, filing cabinets in a room someplace filled with folders and papers that represent discoverable evidence. Does the plaintiff get to come into the office and go through the filing cabinets themselves? Not at first, and usually not at all. In a civil case, the plaintiff would make a request for the production of relevant documents, and then someone at the company, the defendant company, would have to search through the folders and files and filing cabinets and find responsive information. There's a whole industry devoted to this, to the discovery of both electronic and paper information. There's even jobs you can get as an attorney, usually as a new attorney, or maybe when you have some temporary downtime or something, where you basically get paid $15 an hour or $25 an hour to sit in a basement and go through discoverable information and flag papers that are responsive. So if we compare that to the hard drive, is it really right for the plaintiff to get access to the whole hard drive, that they get to go through the files in the filing cabinets and the folders and the papers? Or should the defendant simply respond to a request for specific files, like files that have been downloaded through BitTorrent or files that belong to the plaintiff that were downloaded through BitTorrent? And yeah, I can hear in the back of your mind, you're going, well, the person could just lie. And I get that, and that should be addressed. If there's any evidence that the person has lied, then yeah, the judge and the court will get much more involved there. But we're not there yet. Let's continue. August 17th, in a letter attempting to address the discovery dispute, plaintiff proposed an electronically searchable information protocol, ESI protocol, to which defendant objected. In his objection, defendant offered to produce files subject to a list of search strings. So search strings would be like the titles of the videos, the information hash or the file hash, the cryptographic hash, which should be sort of a fingerprint to a file. So if I download a file, if it's an exact copy of the file that they're saying was downloaded, it'll have the same cryptographic hash. It'll have the same SHA hash or something like that. Yes, it's possible for there to be collisions between hashes or duplicates, but it's extremely rare. And if in a case with discovery, maybe if you had two files that hit on the same fingerprint, then you would just have to look at those files and see if they were really what it was labeled or really what the file was, what you were looking for. The parties met and conferred, as you do before discovery disputes, and were unable to reach an agreement. Discussion. Plaintiff requests the court to compel the production of defendant's hard drives and cloud-based storage for a forensic examination. Plaintiff argues the information contained therein is relevant to both plaintiff's copyright infringement claim and to defendant's defenses. Plaintiff argues that forensic examination is proportional to the needs of the case, given that the burden on defendant is minimal, since he already created mirror images of the hard drives and the cloud accounts. Federal Rule of Civil Procedure 34 allows discovery of electronically stored information, which is limited to any non-privileged matter that is relevant to any party's claim or defense and is proportional to the needs of the case. The notes to the Rule 34 say it is not meant to create a routine right of direct access to a party's electronic information system. like the filing cabinets example, although such access might be justified in some circumstances. In determining if a forensic examination of an electronic device is warranted, courts consider whether the examination will reveal relevant information that is proportional to the needs of the case given any possible privacy or confidentiality concerns. And then the court cites two examples, Henson v. Tern denying the request for forensic imaging of defendant's devices because it might reveal information that is not relevant or privileged and implicate privacy concerns, and Brocade or Brocade communication systems allowing forensic inspection of computer hard drive where the electronic information is relevant to the pending claims. And the judge notes that a forensic examination threatens the disclosure of irrelevant and privileged information. Plaintiff first argues the mirror images of defendant's devices and cloud accounts are relevant to plaintiff's claims and to defendant's own affirmative defenses. There is no question that an examination of these images would reveal information relevant to either proving or disproving plaintiff's case. So the judge agrees that some of the information that would be produced would be directly relevant. Are the files on the hard drive, or are they not? Is there any evidence of the files having been on the hard drive? Any evidence of files being erased? Evidence of maybe hard drives or other devices that were connected that could be relevant? I don't agree as a defense attorney, but trying to put on an unbiased hat here and looking at both sides, yeah, I could see how this would lead to discoverable information. But, the judge says, producing a complete forensic image of defendant's hard drives and accounts will also disclose information that has no relevance to plaintiff's copyright infringement claim, including family photos and personal financial information. Let's say that you had some private photos on there, the kind of photos that you wouldn't want the world to see. And how do you prevent the plaintiff from getting a hold of those things if you've given them your entire hard drive? You can't go in there and erase stuff and then produce the hard drive. They're going to notice that, and it's also spoliation of evidence. Tampering with evidence is highly illegal. See the Henson case, finding a complete forensic image of a cell phone threatens to sweep information bearing no relevance to the case, and listing cases with the same proposition. It would also likely reveal privileged information, which would be communications between you and your attorney, or in this case, they also asserted the spousal privilege, which means the privacy interest between you and your spouse. Plaintiff argues that a protective order would prevent the disclosure of privileged or otherwise private materials. These protective orders can take any form, so we have to look at exactly what the protective order states. For example, in these cases, many times we seek a protective order right away in the beginning of the case so that John Doe defendant's name stays John Doe and doesn't become like the William Mullins case where it's Strike 3 Holdings, or no, that was Malibu Media versus William Mullins. Now Mr. Mullins' name is attached to it. And fortunately, he has cleared his name and he has won his case, but he's still attached to a case that involves videos made for people over the age of 18. Those kinds of things could be prejudicial beyond just the judgment in the court case. So the judge has to address the specific language of any proposed protective order. And here's what the judge says. Plaintiff proposes the following protocol in the event its expert discovers privileged information. Quote, if plaintiff's expert's examination reveals relevant information matching the search criteria above, but the relevant information is privileged, plaintiff's forensic expert will, without disclosing the contents, notify both plaintiff's counsel and defendant's counsel. Defendant will determine whether defendant wishes to assert a claim of privilege. Plaintiffs reserve the right to move the court for an in-camera or with the court inspection of a document that defendant's claim is privileged. Neither plaintiff's forensic expert nor any other person's review of privileged information nor any inadvertent disclosure thereof will constitute a waiver of any privilege by defendant. The court continues, plaintiff's proposed protocol does not adequately address defendant's legitimate privacy and privilege concerns. For example, the protocol provides for plaintiff's expert to make the initial determination of which information may be privileged, which is a pretty big no-no. The defendant and their attorney should be the ones to have the first crack at what is privileged. And the plaintiffs will often, or the opposing party will often ask for a privilege log that logs all of the privileged information on a device or something like that. And so the plaintiff then has a chance to make an objection. So what the plaintiff, strike three, is doing here is reversing that and saying they're going to find the privileged information first, then tell the defendant, and then defendant can assert privilege. It's sort of out of order. Other courts have rejected similar protocols that provide more protection than plaintiff proposes here. In Brocade Communication Systems, the plaintiff proposed an inspection, search, and production protocol that takes many steps to protect defendants' confidential and attorney-client privilege information. For example, by requiring that the forensic expert produce any recovered files to defendant first to allow its counsel to review the files as to relevance, responsiveness, and privilege prior to any disclosure to the plaintiff. The court in Brocade found that plaintiff was not entitled to set the conditions of the inspection unilaterally, nor to select the person who will perform it. There's another case, Advante International Corp., where the court found defendant failed to show it would be appropriate to allow its retained expert to conduct a forensic examination of hard drives, absent any examination protocol. Because plaintiff's protocol does not adequately address defendant's privacy, confidentiality, and privilege concerns, a forensic examination of defendant's devices threatens the disclosure of irrelevant and privileged information. An examination is not proportional to the needs of the case. Plaintiff additionally argues the requested forensic examination is proportional to the needs of the case because 1. Plaintiff's claim implicates important property rights. 2. The amount in controversy in this matter is large and growing. In these strike three cases, I've never seen a strike three case for less than 24 infringements. 24 infringements is around a minimum of $18,000 in minimum statutory damages and much more likely to be over $50,000 in statutory damages, but could be higher depending upon the circumstances of the infringement once the plaintiff is able to prove it. So that includes then, or that doesn't include the plaintiff's attorney's fees and the defendant's expenses paying for their own attorney's fees. So the amount in controversy is rather large. So that's one of their arguments. However, if you go back, if you just pause for a second and think back, what are we talking about? We're talking about infringing upon movies on the internet, on file sharing websites. What is the actual damage here? This gets into a much longer discussion, but maybe a movie is worth $20. Maybe a movie is worth $50. Maybe you have a multiplier because of the infringement or something, but $750 per movie doesn't sound like the appropriate remedy or recovery for BitTorrent-based copyright infringement. However, the other side of that argument is that it's hard to prove what the actual damages are, so the United States Congress set a minimum, $750 per title minimum, $150,000 maximum per infringement for the worst kinds of willful copyright infringement. 3, information asymmetry favors production. I'm not sure what that means. I'm guessing that means that the plaintiff doesn't have any other access to information. 4, defendant's resources are not at issue. Plaintiff bears the cost of examination. 5, the hard drives are critical to resolving the claim and defenses. Plaintiff also contends the only risk in permitting a full review that plaintiff's expert might uncover private information is accounted for by the protections in the proposed ESI protocol. Plaintiff is correct that there is virtually no financial burden, says the court, to defendant if he were to simply turn over copies of his hard drives, which have already been imaged. But while questions of proportionality often arise in the context of disputes about the expense of discovery, proportionality is not limited to just financial considerations. Privacy interests can be a consideration in evaluating proportionality, particularly in the context of a request to inspect personal electronic devices. The Anthem case or excuse me, the previous case cited two cases where courts weighed privacy concerns in determining whether forensic imaging was warranted. The Anthem case denied access to computer systems in light of privacy concerns, and Boston Scientific, I think that's Boston, reasoned that forensic imaging remains highly invasive and engenders the risk of unanticipated accidental disclosure of the crown jewels pronounced in competitor litigation. Plaintiff argues its request is proportional because it has no other way to obtain defendant's files. The court disagrees. The defendant has suggested a number of ways plaintiff could obtain the information it seeks, including the use of ESI search strings. Like I said before, they could search for the titles, they could search for the information hash and the cryptographic hash. I'm not making those hashes up. Those are hashes that the plaintiff provides in the exhibit to their complaint when they file the thing, and they use to support their copyright claim so that it survives a motion to dismiss or survives the initial pleading stage. So this is information the plaintiff already has, and all they have to do is agree that that's how we're going to search for the information. And remember, you're not supposed to get access to the defendant's premises to go through their files and folders and filing cabinets. You're supposed to ask for the information that's relevant, and then the defendant or the opposing party has to produce that information. It is possible defendant's expert could conduct such searches with plaintiff's expert present, so the two could work together to refine searches to obtain the relevant information. The parties disagree about whether it is possible to adequately conduct such searches for movies with names that may have changed, among other factors. That also bothers me. I get that people download things off the internet via piracy websites and use BitTorrent in unauthorized ways and all that. But in my experience, I don't know of anyone, including myself, who downloads these things and then immediately changes the name. Maybe you shorten the name a little bit, but you usually keep the name of the thing. If you download Adobe Photoshop, you don't change it to, Blue's Clues or something. And then even further than that, the info hash and the cryptographic hash would still match. What are they saying? That people are transcribing video from one format to another or from one bit rate to another? No, people are downloading the things. Sometimes they keep them, sometimes they throw them away, and that's really it. There's really no other behavior that I see. People are not downloading gigabytes of high quality movies only to transcribe them to a lower quality format. That's just weird. The court says that plaintiff has not even tried here. As such, plaintiff fails to show that a less intrusive option would not yield the information it seeks. See Tingle v. Herbert. Before defendants could get access to plaintiff's cell phone, they were required to show an attempt to obtain the information by less intrusive means. Undoubtedly, a complete forensic examination would be more reliable and thorough for plaintiff to ensure that it has obtained all relevant information. But given what is at issue in this case, an alleged infringement of 54 movies, requiring defendant to turn over images of his hard drives and cloud accounts to plaintiff is not justified. There is no indication defendant willfully defaulted on his discovery obligations, absent specific concrete evidence of concealment or destruction of evidence. So there's the standard, specific concrete evidence of destruction or concealment. Courts are generally cautious about granting a request for a forensic examination of an adversary's computer. Mere skepticism from the plaintiff that an opposing party has not produced all relevant information is not sufficient to warrant drastic electronic discovery measures. For all these reasons, plaintiff's request for defendants' hard drives for the images and the cloud-based storage system accounts is not proportional to the needs of the case. It is therefore ordered that the motion to compel is denied. And I think that's the right result. And I'm happy about this. And this is a remarkable occurrence because in the past, I was part of one of the first, if not the first, litigation in these kinds of cases, these adult entertainment, BitTorrent copyright infringement cases. And we didn't oppose a request for the defendant's hard drive. That was more based on the financial burden of having to go through all of this, having to generate an ESI protocol and all that. And a little bit of being green in the past year. It was my first case. I was working with 4 more experienced mentor attorneys, and none of them wanted to object to the request for the hard drive. We were actually hoping that the hard drive evidence would exonerate our clients. Unfortunately, it didn't always exonerate clients, as I made a video about the 5th defendant, Brian White, who was not my client, who destroyed his hard drive evidence, erased his hard drive, reinstalled Windows, and through the discovery process, Malibu Media's attorney Keith Lipscomb was able to show that he had done so and obtain a very significant award of $241,000 for 5 infringements because the judge was ticked that he had destroyed his hard drive evidence. But when you think about it, like we just did with that analogy to the file cabinets, it's not proportional. It's not normal to go through all of defendants' or opposing parties' files. It's normal to ask for the information, search for the information, and then if there's some compelling evidence, concrete evidence, as the court said, that there's some more evidence that hasn't been turned over upon the request, relevant evidence, then you can go to the court with a motion to compel, but not before you've tried that. So I think these cases are actually really simple. It really comes down to whether or not defendant did the thing. So it should be just a matter of asking the defendant, did you do the thing, and having them testify under oath whether they did the thing. And if they're suspicious that somebody's lying under oath, well, look at the hard drive, look at the files that were produced by the forensic expert on the defense side, and then if things are really not adding up, then make the motion to compel. But if you don't find any evidence, that doesn't mean that the defendant is still guilty and you get to search the hard drive further and further until you find the evidence. There is a cutoff point where you have to admit that the defendant is innocent if both testimony and a document production reveals that there's no evidence that the defendant committed the infringements. Remember, there are multiple people behind any one internet connection. I've had many clients where there's only one person using the internet. I've also had many clients where there's 5 or 6 or 10 or 12 or 15 or more people using the internet. I've had some clients who provide open internet access to anybody who lives near them or comes and visits. So it really isn't a great way to make the case for file sharing copyright infringement. Sure, I'll concede that the plaintiff sees copyright infringement on the internet. I've used BitTorrent before. I've used the Pirate Bay before. I don't do it anymore since I became an attorney, because who wants to be copyright attorney sued for copyright infringement? I don't want to be the headline. Plus, I can afford to pay for my stuff now, and I couldn't then. So I know from personal experience that there's a lot of infringement going on out there. And how do you prove it? Well, you would have to file the suit. You'd have to hope that discovery produces relevant evidence and proves your claim for you. And if it doesn't, it doesn't. You're taking a chance. It's a fishing expedition. Sometimes you catch a fish. Sometimes you don't. Sometimes you throw the line out there and it's just, the fish just aren't biting. Or in this case, the fish is innocent and doesn't deserve to be hooked and reeled in and made liable for something they didn't do. It's a lot for this plaintiff to assume that every defendant is guilty. And I think it would be a much more fair system if they were somehow forced to take into account that there's multiple people behind an internet connection, and not every person who uses the internet connection is the one that's guilty of the infringement. Anyway, let me know what you think in the comments below. Thank you to Michael Dale for the $20. Keep it up. Your breakdowning cases have become my new addiction. Love all you do. Thank you, Michael. I'm looking forward to a very productive 2022. I have some great ideas for the channel, and we'll see what happens there. I do have a send-off for you here, but before the send-off, let me thank my supporters for December of 2021. Thank you to the $50 plus supporters who support us via patreon.com/ljfrench, sponsors.com/law, through Floatplane, and through YouTube membership. They are John Steele, Gavin Barnard, Eevi, Spirit Bear, Benjamin Hitov, Ugly Grill, Torpedan, ShadowTycho, Earthbound Star, PureMagma, Drew Hart, TechTechPotato, Eric Tams, and the Blood-Soaked Survivors. And now I'm going to try something unscripted. I have here a punch card that I have punched with many holes, and it's attached to a music box, and I thought I would send you off with me playing what's on this card. It will take me just a second, if you want to bear with me, to adjust the microphone, and we'll go to this camera, and I'll be right there. All right, the microphone should be back on. Let's see what we've got here. We've got a card that is flopping all over the place. All right, Happy New Year, everyone. I hope you enjoyed that. Yes, I already did clear that to make sure that it wouldn't get a content ID hit on YouTube. I uploaded it twice already. Anyway, love you guys. Hope you have a great new year. We're going to do a Twitch stream of us playing some Jackbox games later. I think there's a new Jackbox 8 out or something like that. So we will make an announcement on the Lawful Masses Discord channel that will be on twitch.tv/lawfulmasses. I don't know what time. My wife and I are going to go have gourmetin, our New Year's celebration where we cook meats and things on the raclette, and then we'll be back for that later. I love you all. Have a happy new year, and I will see you in a productive and hopefully less COVID 2022, although I don't think it's going to be as less COVID as we'd like, but hopefully we get through it together with a minimum of inconvenience and death. Anyway, love you all. Have a good one. Happy New Year. Bye.